that time Gujarat government under the stewardship of CM Modi at that time took AI as a very serious objective, and I continued doing so. In 2015, I was in the launch team on the shadow of Digital India. Then in 2020, I launched a major campaign on AI, which was a global conference, online conference addressed by Modi Sir called RAISE, Responsible AI in Social Empowerment. So that's all about little bit on the background. Now I would like to say that AI has suddenly not appeared in the horizon. AI has been around for many years. In fact, before my birth. In fact, I was born in 1957, around this time when the first satellite went up, Sputnik. And little before, AI was created by a group of American researchers, mathematicians, and scientists in USA. And it was not much heard because it was kept in the realm of security, defense, and that kind of thing. The first major scope of AI was seen when Mr. Armstrong and Mr. Aldrin touched the moon surface, and it was guided by AI from the Jet Propulsion Lab of NASA. And later on, when Apollo-Soyuz space docking happened, Russians came to know that Americans used something called artificial intelligence to guide their thing. But those are all very old. So I would now like to bring the topic that in one of the major sessions of WIPO 2 weeks back, I heard one of my friend Barry speak on the intersection of AI and IPR. In fact, it is very relevant, and it is very much true to the cause of today that American Hollywood industry was stuck down for nearly 6 months due to a strike between the creators and the users, or in their opinion, misusers of AI, and the copyrights were violated, contents were taken away without permission or without royalty or anything. So now there is a real good reason for all of us to look at how one can bring the IPR as a value and as a realizable asset onto the AI platform, so that the AI strengthens IPR or IPR gets strengthened by the use of AI, whichever way you look at it. But my looking at it as a content person in creative industry is that AI should be used as a tool for strengthening the IPR, strengthening the content creation, and giving a higher value of satisfaction to the audience. One major example is Part-2 film by Cameroon, which was very highly AI assisted video, very highly AI dominated, controlled, manipulated, whatever good or bad words one can say, in the studio in New Zealand, Weta Digital, of another great filmmaker, Peter Jackson. James Cameron created Part-2 and Part-3 and now going for Part-4, all of which are heavily controlled and managed through specific application, very customized application, and highly thoughtful orientation of AI in them. I am not going into the details of any of this because time is short and I don't want to trouble others. But any of you who are interested to learn how Cameroon used AI and what I saw with my own eyes in Canada and New Zealand, being an invitee that he has, his team members, Umesh and Reddy, called me to see and to get inspired so that we can bring the same technology into India. Not a commercial proposition, but India being the biggest content creation industry and creative personalities residing nation, we must be able to take on the list or latest and create more and more sophisticated content, more and more creative content, and more content of value for TV, for film, for music, all kind of artistic and creative application, which will always satisfy everybody. And I am very happy that at this time, our Indian Parliament and regulators adopted the new copyright legislation or modification, which will certainly inspire the creative community in India and across the world to say that here is a country which is not only put a satellite or a rocket on moon and done many more things, one of the highest speeding up of GDP and so many things, but it is also very concerned with its creative population, very highly interested to see the creative people create more. And at the same time, our Honorable Prime Minister has many times in many international tours and many of his speeches have said, we would be independent, we would be by ourselves, but we'll always work with the best of global thought leaders so that the world gets benefit of the responsible AI, that India will take a leadership. And in fact, in the next year, India is also chairing the global AI conference, like in the same line of G20. And I can see a lot of speeches from Honorable Minister Vaishnav and Honorable Minister Rajiv talking about it. And I feel our forum, where we have experts in this area, can always drive the matter. And I would request Madam and sirs here that we should take it upon ourselves to prove India is not a laggard like one very audacious person from Silicon Valley has spoken some time back, which is heavily contested by everybody from India and also people in USA. And we feel that we join hands, group together, apply our intellectual capabilities and our brain power to do many more things. And that would mean AI to be used for content protection, for cyber protection of a higher level. We call it quantum protection. It is something that cannot be even broken by a quantum computer, because the normal content protection systems that are used currently can be broken by a quantum computer in fraction of a second. So we need to also empower our content protection to face any eventuality where some bad guys would try to break in and take our rights away. So that's all about it, doing good on one hand and protecting our downside from bad. And I feel NasCap will bring all the UN bodies, including ITU and others, to do that. And I'm happy to answer any question now or later. And very grateful to all of you who have given me the chance. I hold also about 27 IPs in AI, which are developed with my international team members, all of whom are ready to work with our Indian community and help, guide, support, or take us forward in the right direction. Thank you for your time, and I am calling off.
Thank you, sir, for giving us the historic perspective of AI and how it actually, we never knew. I mean, now it has become very common. Common people are using it, but thank you for giving a perspective to it. And AI has been there from very long time. We knew about it, but yes, the details of it. Thank you for sharing it. Any questions from Shri Amit ji? Amit Dev ji?
Dinesh, just for 1 minute. Mr. Amit Dev ji, I am the Pinaki Ghosh. I am the co-founder with Dinesh of the NasCap. So actually what we need, we have a different verticals. Can you hear me?
Yeah, I can hear you.
Yeah, I can hear you. Yeah, we have the different verticals regarding the piracy and the anti-counterfeit. So I will work very closely with you along with the leadership of Mr. Supran Sen to make this piracy, anti-piracy, anti-counterfeit related work offline. We're going to talk on with you. If you spare some time with us, then it will be nice.
I think this session is already little down on the time. So I would not like to take it further forward and disturb the schedule of the later speakers. And we would like to take this question offline, and any other question that comes, Madam Jasmine can forward them to me, and I promise that in over the weekend I'll take time out to answer each person through a video clip so that they can understand. And if they have further question, I'll be too happy to further answer, because I am more like a consultant or an advisor, and my friends all across the world in 9 countries are all devoted to growth of AI and application of AI in creative areas. We call it creativity tech. So how we can take forward, and how India can, from a creative leader, can be a creativity tech leader in future. Thank you all. Have a great day.
Thank you, sir. Thank you. Thank you for making it. Okay, may I now request Rima Ghosh? And again, as we know that we have overshot in the time, so I'll request Rima to conclude in 22 minutes, and then we have a fruitful. I want an I'm always in favor of interactive sessions, so we'll take up questions from the audience after that. So Rima is she's a PhD scholar at West Bengal National University of Judicial Sciences on in IPR, and it will be really good to have your views, because you are doing research right now. You're a scholar right now, and there will be newer areas that you are touching upon in IPRs, especially copyrights, where you can share your knowledge with us. So, Rima, over to you.
Am I audible, sir?
Yes, absolutely.
Yeah, you're audible.
First of all, thank you, sir, Dinesh sir, and my guide, Pinaki sir, for giving me this opportunity to speak on this topic. So, a very good afternoon, one and all present here, my respective speakers and my dear students. So, actually, my topic has already been talked by Raghavendra sir. So, I'd like to give a practical experience as a scholar. What did I face? Because I am particularly working under Pinaki sir's supervisions, like how to protect expression in the entertainment industry and how it actually works. But sir, when I'm doing the research till now, I'm very sorry to say that sir, our industry doesn't know about copyright. There's a very lack of knowledge. When I went to the industry, specifically with the actors, when I had a discussion with them, they are basically depending on hierarchical process, and they have a hierarchical rules. So I feel bad somewhere our knowledge I mean not been acknowledged or been not known. And moreover, as we are talking about entertainment industry. It is very sorry to say that people have a wrong notion. Entertainment industry means film, but no, it's not at all. It is not at all. Entertainment industry is connected with film, music, spiritual, educations, any form of entertainment which we get. In fact, everybody agrees with me. Movies are being liked by everybody. Everybody agrees. Yes, sir. I want this to be interactive. Students, please respond. Because saying it will not say. If you respond, if you make it interactive, I think it will be more helpful to you. See, I'm also a student, so I want the students, please, to be interactive. Maybe now or after the session, you can ask questions, so it will be more interesting. So I'll share with you how it actually happens. So as I said, the entertainment industry is basically not only related to film or music. It has lot of dimensions like music, film, education, spiritual, even the sports, TV serials, commercials. It's a huge, even the YouTubes. We can't forget that how YouTubers are earning money. I mean, we can say from us, they are earning huge and huge money. This is the main reason how our industry is flourishing. And this industry is flourishing like anything across the globe. It's economical perspective, anywhere. So I could rather say that IP plays a very important role in film industry from script to script. It has been said that the role of IP is very important, especially with the copyright, how it actually helps. I have a small PPT I'd like to share. So sorry, I think it's a technical glitch. It's not sharing.
Hope it is not controversy.
Yeah, I think it's no, sir. It's not. Since I'm so sorry. Actually, I've made a PPT. It's not sharing. Maybe because actually, in our institution, there's a work is going on. Maybe there's internet issues. It's not sharing. I'm so sorry. So I'll give a brief description how it actually works. This industry. First of all, it's a huge player industry. It is not a single-handed industry. Actually, we see when we in film industry, when we talk about, there's a script writer to fashion designer, how it actually works. If we see a script writer, which is very important thing, a film is depend. For example, I can give us example of Two States. I think everybody have heard the movie Two States. It is based on a novel like Chetan Bhagat. Here we can see how it actually happens. Since copyright says that we cannot take anybody's work without permissions. We need to take a permission to use somebody's work. But nowadays, as we know, everybody knows how piracy is going on each and every day. I mean, basically, South movies, we see every day it has been copied and used. But this is actually wrong. How it can be done? So again, there is a concept of idea expression dichotomy, and which is one of the most debating concept in copyright. As we can see that we say that in our previous talk, Dr. Samuel was talking about idea expression dichotomy, that idea cannot be protected, only expressions. But the concept, how idea, because no one knows how it actually works. We shout and say copyright, it works, copyright has an important role in entertainment industry, but how it works, nobody has the idea. Since like in when we talk, when we discuss with these things, people have very little lack and people lack of knowledge. So in Calcutta, we have started initiative by Dr. Pinaki sir, like we visit different colleges. So we visit different colleges to give students the importance of copyright, IPR, how it works. Because I believe, from our tender days, from a young days, if you have a knowledge of this specific subject, we can go further. And moreover, in this film industry or any type of entertainment industry which we get, the youngsters are coming up. They are very interesting. They know about it. So, sir, I can say that there is a lack of knowledge, lack of awareness in this particular topic, which is need to be taken up. Like you, like professors, should come up. That should be the main problem I face. That is the main awareness. Secondly, if I talk about idea expression and dichotomy, as ma'am has already told, idea cannot be protected. Only expression can be protected. But the thing is that the question arises how an idea becomes expressions. Yeah, ma'am was talking about merger and doctrine. Like when idea merge with doctrine, it becomes collaborative. It cannot be separate. But there are several provisions. There are several ways we can say that this is protection. How this can be protected in expressions. So when an idea, we use our labor, skill, and judgment, that becomes an expression. Actually, this concept, idea expression dichotomy, was first originated in US from the case called Seldom versus Baker. There was a case based on book accounting system where this case where the book accounting to keep the arrange the book, from that case this concept came idea expression dichotomy. Gradually in India, as ma'am had already told, from the case R.G. Anand versus Duelist Films. I guess everybody knows this film, Archie Anand was a Duelist film, because in this film we have seen that the movie was being stolen by the act, which was written by Archie Anand. So from there the concept come. But now the question arises, how when we say that copyright is to be protected, copyright is an important part, it is protected, it's given right to the performers, artists, writers, but how we differentiate the products, which is original, which is not original? How we differentiate? This is one of the most important, and since I'm doing research in a particular area, I can feel the pain, because when I talk to several of the artists and all, they were like, we get what our hierarchy comes, we work like that. So how to protect creative content? Since, because if it doesn't protect our creative content, in near future we will not find original works. And this, although this piracy is going on, we cannot stop it. It is an ongoing process. There are debates are going on, coming up, but it's an ongoing process. So it's become a very difficult, how to actually handle this. There are several cases still going on because the doctrine is, it's just a doctrine, it's not a law. Copyright is just a doctrine on how we should protect. So there are several tests are there. There are several tests is coming up, like separability test. We can separate it, particular movie when we talk about what thing is when original, which is not original. And that is, and I believe that is one of the most important essential thing we need to do. Because by this not we not protect our copyright. Moreover, when I talk, like, this film industry is huge industry, economic perspectives growing enoughly. There's a huge players, and each of the players are having their own content, own creative. But why they are getting recognition? Only the producer and the film director who is getting. Where are the other peoples? There are peoples. They are working hard. Equally, they are working hard. So why not we think about them? We just know the music and the script writers. Yeah, we acknowledge that these two peoples are very important, but there are other peoples too. When we are protecting copyright to everyone, one are these peoples? And how we can say the script to screen? When we see the script to screen, the entire journey isn't based on IP, the specific copyright. How it arises? So these are the main problem I face, and I think they should be taken for considerations. We have talks, we talk about that. There are economic perspective. So if we don't, I think if we don't protect this expression, I think it's in near future there will be films coming up, piracy will be going on. Again, I can share my practical knowledge. When I went to Satyajit Roy Film Institute, when I was talking with the professors and the students, I feel that they doesn't have a subject on IP. They basically, they're studying, they're getting degree, they're working on the industry, but where are they not subjects? How will you protect your content? They don't know, sir. Our topic is how to protect our content. If you don't know the solution, how will we protect our content? And I believe, sir, there is a high time we should think on this particular matter. There should be, awareness. The specific subject should be there. We talk, we finish. That's enough. That's not enough, I guess. There should be a specific subject to holding that, particular area, specifically how to protect this copyright. There are cases coming up. Several cases got mediations, out of the court settlement, and done. What about the next? Specifically as a student, I feel that there should be, there should be mechanism, there should be awareness to protect this particular concept, and people should know about this topic. We say about copyright, we talk about IP. There are many provisions, but how? Even, sir, we can say that the movies which are, loved by everybody, from old age to children to old age, everybody love movies. In fact, in our past time, we watch movies. In fact, going to a movie hall, going to a multiplex, paying to a huge amount. It's a huge. If I can say, watching a movie, it takes almost 1,000 rupees. So it's a huge. If you're not getting creative content, how it will work? So I think it's a time we should really think about that, and then it can really work in. Again, the role of cinematography is very well connected. There are acts, there are laws, it's happening, but there are duration. People take protections. We get 60 years. It's a going. Even if we talk about Cinematography Act, which come newly, there has been written that film certification is important. The certification it's been going important, and the child rights also. But these are okay, but I think there is somewhere we are lacking in the provisions, to protect our thing. Because when I was talking to the industry perspective, I feel that there are lack of awareness and knowledge. People should aware of it. It is one of the most important thing. I think it should be taken up. Secondly, I believe, sir, that in our industry, it's huge. People are coming up. There are great job opportunities. Economic perspective is there. Again, there is another important provision I can say. If we see today in our restaurant, cafes, multiplex, the malls, the musics are being created, the plates. There also, they are not giving any revenue to the concerned person. Without their permission, they are being used it. Although there's exception clauses on the Copyright Act 1952, that there are exception clauses that you can use it. But nowadays, even in the events, even in the marriage institution, we see that the music has been played by the DJs. They're earning huge. Why can't they pay small amount as a remuneration to to the original creators? Get helpful. But sir, there are some lacks. So although my research is going on, but I believe that it's high time we should think about it, and we should, we should take a necessary measures. Thank you, sir. Any questions? Anybody? Students?
Have you gone through the latest Cinematography Act amendment?
Yes, sir. Yes, sir. I went it.
It has got certain provisions in which I will be telling after some
Sir,
time.
which
Now,
I have.
Rima, 1 minute. With the digitalization, this piracy, and whenever you have a film, if you want to show it, you have to give a KDM. So that is why it is not so easy to get the things pirated. Earlier it was, but not now. See, any film I want to release, I need a KDM for the producer. He will give me the number, or he will give me some sort of a code number. Then only I can release it. So it's not so easy. That's what I'm saying. It is there. Piracy will always be there, but it is there.
But sir, people are not aware of it. Now that is the main thing. Sir,
People are
you
aware.
said
No,
there are many like.
Exactly. But the time is too short, so I won't be able to speak much because I have also to leave.
Sir, I'm really looking forward to your lectures. So I'll also want to learn. Okay, sir. Okay, sir. Okay, sir. Any questions?
Rima, I believe you are a research scholar with WJUS,
Yes,
right? Yeah. So one thing I was pretty intrigued to hear that nobody is aware of a lot of things about the film industry. I was quite intrigued to hear that.
Yes, sir.
And
Actually,
if you have the patience to listen to what I want to say, and the several issues that you have raised about remuneration, about a lot of things, you've raised multiple issues. I hope your hypothesis is limited to few questions and not so broad-based. But the only thing I would like to add is that a lot of things that you have raised are already taken care of. A lot of things that you are referring to, and particularly the last thing of the last person, the usage and the royalty not being paid. Yes, it's not completely there, but just for your information, IPRS is doing a massive work, a very significant work in collecting revenues from each and every platform wherever these songs are being exploited. But it's always a transactional cost. Where do you go and enforce your rights? You don't go and enforce your rights in a small village or a small district. Wherever there is a big hotels, wherever there are big restaurants, the revenues and the royalties are collected by IPRS. There is a scheme of revenue, scheme of fee, which is mentioned on the IPRS website, and they have their work. They have their enforcement divisions who go and check it. ISRA does it for the Singers Association in a very in a very active manner. So I would recommend that you please be better informed about these various things. And let me tell you, a lot of people, maybe in the Satyajit Ray Film Institute, people are not so updated. But, and there is no chapter on, there is no course on IP. But in many other film institutes, there are courses on IP. And a lot of people are these days very much aware of these things in a much more effective way. So that's my 2 bits on this. Sorry.
Okay. So in the interest of time, I would like to move on and thank Rima about her informative session. We can, if there are any follow-up questions, Rima ji, I'll get back to you and an email, and then we can, we have a list of all the audiences right now registered. We'll share the question and answer there. Thank you so much, Rima ji. Moving on to the next session, Sir has been associated, Mr. Supran Sen has been associated with NasCap, I think from very long time now. And he has a very vast and deep experience. He's also Secretary General of Film Federation of India. So it's really, our pleasure, sir, to attend to your session and hear your views. Your topic is copyright in cinematography. So I know we did hear, we were informed a lot in Dr. Raghuvendra's session about the copyrights in cinematography. But sir, would be pleasure to hear from you, and if you can take that forward.
So thank you very much. After Dr. Raghavendra Singh spoke, I don't think there is anything left now. After his excellent speech, as I said, I was present with him in various conferences of WIPO, and he's really wonderful and his knowledge. So, but sir, but the thing is, the time is too short, and I am also to leave. So I will just harp on certain issues. Basically, I said that I will be talking on the amendment in the cinematograph vis-a-vis the copyright, right, sir? So it is very interesting. Ever since the piracy was getting rampant, when the piracy came, 1952, and all that, the Copyright Act came, the main agenda before the industry, film industry, was how to stop the menace. There are various sources. We started with this, we then reading. Even we used to meet the political people, and later on we came to know that even I'm sorry to say that the politicians were involved in this. In one of the cases, what happened, sir, that there was piracy going on in some other state, that is in Haryana. A Delhi police team went to Haryana, and the head of the team was arrested because that thing was run by a politician. Anyway, that's besides. Now, all the representations made to the government could not bring positive results. This is despite the fact that the piracy is a non-billable and cognizable offense, right, sir? Now, I am very much surprised that how this particular copyright thing has been invoked in the Cinematography Act. It is already an act. It is already existing. But then I don't know what is the main reason behind the government of India to bring again the copyright and this copyright thing. Now, like with the technological development, made with the digitalization, it is controlled to some extent. I mean the piracy. And cinematograph was amended further, which inter alia provides for both deterrent punishment. But the catch is, among the punishment, they say that the pirates, the 5% of the gross production cost will be taken from the pirates. How will you assess that amount? Because now the pirates are not multinational people. So they operate from a very, very small place. So the audited accounts, whatever, I don't think they have any audited accounts also. But then how will you judge? That's a very important issue, and we must raise it. So there is an amendment. The 5% will. How will you detect that 5%? From where will you get that? That is very important. Now, this also means if I pay 5%, I can get away with this. Chori karke main paisa deke I will nikal jaunga. So that is also very, very, very difficult. Otherwise, you can put some particular amount, that 2 lakh, 5 lakh, 6 lakh, whatever. Since it is cognizable offense, so you can put it like that. But then this act doesn't clear. It's not clear. Cinematograph amendment came into existence after long deliberations. I was part of two very big committees like Mudgal Committee and Chamber Legal Committee. Part means I just had to spoke something. I'm not a member of that, but then I spoke it. So now they made certain amendments. Now, but when it was presented, the government overlooked that. Now, after a long time, they have made certain provisions like the censorship rules, then the UA certificate, 7 plus, 7 plus, 11 plus, like that. The plus, they have made it. So that means what? That means when I take my child, say he is about 7 and plus, I have to carry his photo ID with him, his school cert, whatever it is. So these are all things which should be clear, that how can I judge all these things? Now, there is another very interesting point in the amendment. They say that the issuance of separate certificate for TV, perpetual certificate for film. Now, TV, for which there is already film is censored, certificate is issued. The same film can be shown on the television. But why there is a separate certificate for that? At the most, you can say that the adult movie cannot be shown. That is fine. For that, there is a provision that you have to make it UA certificate. Then only you can show. Then why? Why this? Another thing is, the very, very interesting thing is that they have made the censor as perpetual. Hitherto, it was 10 years. Validity was 10 years, and then after 10 years, it was subject to renewal. Now it is perpetual. If I make a film, I become permanent. I mean, nobody can touch it. How can it be possible? Suppose there is a film called Mr. X, and someone else wants to make a Mr. X. That means he cannot make any time because it's a perpetual. that should be made clear absolutely what exactly the explanation, and they should very, very clear about it. Now, there is a withdrawal of the government's power to recall. Now, either to what used to happen, if the parliament, there is a discussion that there is a particular scene and particular, whatever it is, a political thing. So they will call back, and they will call back and ask for the recensoring. So now that provision has gone, that's a very good decision. But what happened to those political parties or Bajrang Dal type groups, which, they come out with a flag and they say that you cannot show this film. So there should be some sort of, for them also, that these type of people should be there is some provision that this is in the CRPC or whatever it is, or IPC or even Copyright Act, that should be invoked. So what I'm going to say, since the time is too short, I will not be able to say much about it. The thing is that there are provisions made in the Cinematography Act. Number one, why this Copyright Act things have been invoked in this? That is a very important issue. But there is already Copyright Act says that there is a punishable, this cognizable, non-bailable, etc., whatever it is. But why then in this? As I told Rima, that there is a digitalization, definitely it has taken care of the piracy. Piracy is, I can say that piracy is reduced to a very great extent, but there are piracy. Especially the music piracy is very rampant. So what I want to say is that these things we should, on behalf of NasCap, we should make a presentation to the government and definitely ask for the explanations of this. I'm sorry, I won't be able to have to leave. Thank you very much. If any question. Anybody has about any question?
Sir, I have a question.
What happened?
Sir, I have a question.
बोलो ना, पूछो.
सर वो जो नया जो सिनेमेटोग्राफी एक्ट का जो चाइल्ड का जो सेक्शंस है ना, that it has been given that
7
the
plus,
child,
30 plus,
yes,
11 plus. Yeah,
yes, sir.
yeah.
So my question is like that, when the child enters into any cinema or any TV ad shows, the contract are been signed by their guardians. Okay. So sir, the child have a right to sue the guardians?
Sorry?
The
Child?
child rights. Child who comes to in the cinema and the ad, any
Yeah,
TV
cinema halls or anywhere. Cinema hall, let us say,
ad
yeah,
show.
with her parents.
Yeah, with her parents. Since they are minor, so they sign the contract by their guardian. I mean, the guardian signed the contract since they are minor. So does the child have a right to sue their parents?
No. You see, it is not open to him that, though it is 7 plus, like 16 plus, but that does not mean that you can take him to the adult movie. It is only for the universal movies where you can take the child, and 7 plus, 16 plus, whatever it is, that basically not vulgar type of a film. There are some horror films, there are certain lots of things, there is violence, etc., etc. So that is why, because to protect that the child should not get scared about it. So that is why this provision is made. But definitely not that adult things. It's not adult.
Okay.
Any other remark? So thank you, Mr. Dinesh. I'm sorry that the time is too short, so I just couldn't elaborate much. We'll meet
Thank you so much, sir, for sharing your vast experience and deep experience. And
sir, 1 minute, I want a clarification that I was the Secretary General of Film Production India.
Oh,
now I am the executive director of Indian Chamber of Motion Picture.
okay.
So I of course wrote to yes. And of course, NasCap, I am the chairman of Film Committee.
Yes, sir. Yes, sir. Sorry for that mistake.
No problem.
All right. So we have next speaker from the legal background and very important personality, Mr. Ayan Roy Chaudhary. And thank you, Ayan ji, for making it here and sharing your views. Ayan Roy Chaudhary, he is the head of legal and compliance at Broadcast Audience Research Council, BARC. And with nearly more than 2 decades of experience, he's been in this industry. And today's topic of Mr. Ayan Roy Chaudhary is going to be fair use and copyright exceptions. So very important and very controversial actually, and very unsettled also. Analyzing fair use and other exceptions in context of the film, how to determine if the usage qualifies. So
Can you see me?
uh, I cannot.
I cannot see myself, so I don't know what is problem.
We can hear you, Ayon.
That is enough, I think. I'm not that handsome.
That is, I can hear you. Nobody's interested in your face.
Yes, I know. I'm not as handsome as Mr. Sain or Mr. Jotwani. So my so let me speak.
Thank you.
Just put up my
Thank you for that assurance. But we know we
want
saw
to hear
you on
you.
LinkedIn.
Want to hear you.
Let me put up my presentation so that it is up for everyone to see, if not anything else. Just a second, please. And I have some time at my disposal, I believe, because just a minute. What is this? So hold on a second, please. Just a minute. Just give me 5 minutes. Let me just multiple windows that are open right now. And I was a bit surprised because the session is running faster than it should, even after so much of consuming talks by a lot of people. So just a minute. Let me just close some of the windows. It is clogging the space, I believe. Yeah, that should be fine. Right. I still can't understand why is the presentation not coming. Just a minute, please. That's good. Right. Can you see it now, the presentation, please?
Yes.
Right. Thank you very much. So I was quite intrigued with a lot of discussion today on a lot of topics on copyright from the academics, the bureaucrat, ex-bureaucrat, industry person, and academics, the academic scholars. I would like to bring into perspective few things, few practical aspects of the film industry. It's one thing to drop examples, and it's another thing to actually face these situations. Believe me, day in and day out, when I was right now for last 1 year almost, I am not exactly in the film industry, but till such time I have been in and completely since 2008, I have been in the film industry. And it's film industry barring 1.5 years in the music industry. So the practical problems that we face in terms of the usage of various materials in the film and the practical aspects surrounding the films are difficult to summarize in a one-day workshop. In fact, I recently in the beginning of this year held a session in FTII, and I thought I would be in a position to cover almost all the topics related to copyright in film production, but I could not. Even it was an entire day session. So be it as it may, just to give you a perspective of how important the film industry is, as far as Indian film industry is rather, which is popularly called Bollywood. A lot of people have problems saying that. It is one of the fastest growing film markets in the world, even faster than USA in terms of the number of films that is being made, and the entire comeback post-COVID entire turnaround post-COVID has been driven by the film industry. And that is one of the reasons why companies like Netflix also, in spite of a lot of sharing of password and all the mischiefs that Indian smart people are accustomed to do, they still stick on to this industry because it's the name of the it's the game of the numbers around here. So just to put your perspective, that in 2021, around 1,800 films were made and 20% of unscaled value. So this entire global market was driven by the Indian film industry. The M&E sector was driven by the film industry. And if I have to just look at the numbers, I'm not looking at the entire entertainment industry, but if you in this chart, if you can just see, let me just expand this chart here. If you can see, the film entertainment industry is humongous. The growth, the projected growth, and the growth of just the film entertainment industry is humongous. It dropped between 19 and 20 because of COVID, and again from 22, it picked up. I have been associated with one of the first films post-COVID which was released and which gained a lot of, with which the entire box office return happened, although it again scaled down. The film was Suryavanshi. I was not part of Suryavanshi film per se. I was part of the organization which produced it. And then there was 83. These are the two defining films that happened in those 2 years. So yes, this film industry is a significant part of, in one of the studies a few years back, pre-COVID, it contributed to 2% of the economy. And the film industry per se, the Copyright Act per se, and a lot of other legislations also, including Cinematography Act, of course. But Copyright Act is the physiology of this industry, is the bone and muscles, and the basic is the DNA of this M&E sector, including the film industry. So at the heart of the film industry is the film, and around it are these various works which are defined separate works in the Copyright Act: literary, musical, performance, artistic, and film itself is a work. Just to give you an overview, how the cost structures are there in the film agreements. One is a cost vertical, one is a revenue vertical, and one is an allied cost stroke revenue vertical. Cost is ATL and BTL, above the line. Below the line, revenue is digital, non-digital, and derivative, futuristic. Allied is marketing, advertisement, PR, and futuristic revenue streams, and also cost streams. This is the revenue model generally in any film industry, not only India, any film industry. This is the model: theatrical, non-theatrical, domestic, theatrical, overseas theatrical, non-theatrical, television, music, digital, OTT. Ancillary is like the ships and the hotels and the airborne rights, such commercial rights. And then, of course, there is a new frontier which is opening up of metaverse, non-fungible tokens, and the artificial intelligence. Now, coming to the definitions and what are we trying to decipher here, before I delve more deeper into Section 52 of the Copyright Act, where the fair dealing pertaining to fair dealing per se under the copyright is defined, let me just go through the definitions. The Copyright Act defines cinematography films as means any work of visual recording and includes the sound recording accompanying such visual recording, and cinematograph shall be construed as including any work produced by any process analogous to cinematography, including video films. Now, this term video films was included in '94. Before that, video films was not there because videos were made and people who were infringing the copyright were getting away saying the videos are not cinematograph films, only something which is shown in the theaters is cinematograph films. So video films was included, the term video films was included there. Again, the term visual recording was included in the 2012 amendment, and the term visual recording was defined in a broader sense by adding X to Section 2 XXA, which means the recording in any medium by any method, including the storing of it in any electronic means of moving images or of representations from which they can be perceived, reproduced, or communicated by any method. So this is the definition of a cinematograph film in the Copyright Act. Now, remember one thing, I'm not getting into it, but apart from the industry people, the academics, and any other person, they would know that unlike literary, musical, and artistic work, sound recording and cinematograph films are not original work. Now, why they are not original work? Because they are all didactic works. They are not original per se. So under the Copyright Act, the term original is only assigned to these three classes of work: literary, musical, dramatic, and artistic work. Anything other than this is didactic work. They're deduced from, they're made up of, because sound recording is comprised of what? It is comprised of lyrics, music composition, and performance. Cinematograph film consists of so many other things: literary work, dramatic work, performances, musical work as background music, and of course the sound recording or the tracks which forms the songs of the films, and of course the artistic work which goes around in the making of the film. So all this, all these two things, these two works are not original. They are all didactic works. Why is that important in our definition? Because in our understanding of what I am trying to say today in fair dealing is because if the work is original, there is a concept of infringement attached to it. If there is a literary work, if I have written something, then there is a degree of originality, is presumed originality to it, of course, unless I have copied it from somewhere. Now, what is an infringement? Before I delve into what is infringement and what is not copying and etc., and I keep saying this in various talks, there's a book, and I want to show you that book if I can, but my camera is not working. But that book is called Kavya Mimamsa of Rajshekhar. This is a Sanskrit scholar of 10th century AD. He had written a book called Kavya Mimamsa on Kavya Sanskrit. In this, in one of the explanations, he has gone into the depth of what is an infringement, what is the nature of infringement, and what we are trying to decipher today as transformative use, adaptive use, and derivative use. What are these three different kinds of use? Understanding of these things are very important to understand the defense to copyright infringement. And what is, when it is used in a film, can be a fair use versus a fair dealing. Why is it important? I want to use a clip of an existing film in my own film. I'm a producer. I want to use a clip of a film in my own film. I want to use sound recording, a clip of a sound recording in my own film. I want to use a composition bereft of lyrics, bereft of sound recording, just the composition, just the tune in my film. And I, of course, want to use just the lyrics of a particular film in my film. I want to use some artistic work in my film, or I want to use some literary work, not its entirety, but in bits and pieces. How much of that can be used in a film? How much of that cannot be used in a film? What is a de minimis in Indian law? For all of you, I believe you know it is what is de minimis principle, which is irrelevant or something that the court should ignore while allowing a person to use it. These principles, as they stand, is on one hand, and on the other hand is the digital revolution that is happening today. And firsthand, I have experienced how these definitions do not conform to the digital revolution which is happening for some time now and which is going to happen through as we go through this entire process of artificial intelligence thing, you know, we will discover how things change. Just in one of the posts, somebody had written that this artificial intelligence is not going to have any problems. I've written it in my some of the posts on Facebook and otherwise, that there was a film called Naya Daur of Dilip Kumar and Vaijayanti Mala. Sathi Hath Badana Sathi, that's one of his famous songs. The film is about use of bullock cart versus use of bus. There's one group of people who are trying to prevent bus being driven on a particular road where the livelihood of people depends on the use of horse carts. And then, of course, the buses were to be used, and people, of course, opposed it. But did it lead to any disruptions in the livelihood of people? It did. So it happened when the computers came. I still remember the days when there was a section in a law firm dedicated only to the typists, and there was the young age lawyers like us who were joining the workforce, and we were using computers. And over a period of time, the typists just vanished, almost gone. So these disruptions because of the new technology will not stop. What has to evolve is the law. What has to evolve is the policies. What has to evolve is our response to the technology. If we say, and some of the speakers have been saying, and applying the old age formula to the new age technology, that will be really difficult for reasons we will see in this presentation. Right now, dealing with fair deal and fair use. What is a fair use? And what is the difference, fundamental difference between fair use and fair deal? Fair use is a permitted copying of a copyright material not specifically enumerated in law. In one way to say it would be that it's a creation of court decisions. And what is fair dealing? Fair dealing is a defense to the Copyright Infringement Act. Copyright infringement in the Copyright Act, specific acts enumerated in the law which do not constitute copyright infringement. It's statutory in nature. So one is the creation of court, one is the statutory enumerations. To put it otherwise, if you can see this chart, applicability of it, fair use, and it is important to understand it as a defense, because then only I can tell you how the film industry works when it comes to these two types of uses. Fair use application list is quite illustrative and subjective because it is not there in the law. It's not there in the statute books. Fair dealing only apply to those uses or exceptions mentioned in the law. Scope, fair use is a wider scope, i.e. to determine what is fair in the use of a copyrighted material. It may not be fair dealing, but it can be still a fair use. What is a fair use? For example, parody is a fair use, although it is not defined in the Copyright Act. In our Copyright Act, it's there in the UK. It's our Copyright Act, Indian Copyright Act. Fair parody is not a defense, is not a fair dealing. But can it be a fair use? Can parody be used as a defense against, or can we use parody with our right of freedom of expression as a defense against copyright infringement? Questions. I don't know the answers, and there are no definitive answers in Indian precedent either. But more or less, courts in India have stuck to, as we'll see, to the fair dealing part and not to the fair use part. But in US, courts have evolved the entire scope of the fair use. Nature of use. Now, fair use is flexible, resistant to change, and especially those that lead to uncertainty. Fair dealing exceptions are said to be uncertain too, especially for terms like parody and satire that are not defined in any provision. In the Indian context, I'm saying, wherever they're defined, they're fine. What are the questions that are to be answered in a fair use? How much of a copyrighted work has been copied? Did the user make a valuable portion of that copyright work? Which is, for example, just to give a simple example, I don't know how many of you have seen the recent web series called Janeman. Jane Ja or Janeman, with two FTI students and Kareena Kapoor in it. If you see that web series, and this is not a spoiler, but please, this is an example in a presentation, so please do, pardon me for the spoiler, even if it is. And I have been part of this, so I know this. If you see the Janeman series, it is based on a book called Devotion of Suspect X. Devotion of Suspect X is a Japanese novel by a Japanese author. What is the USP of that? The USP is that there is a murder and the body cannot be found. See Janeman and then go out and see another film called Drishyam. I hope all of you, or some of you, might have seen Drishyam. If you see Drishyam, the USP of that film is also the Drishyam 1, I am saying. Drishyam 2 is, of course, different. Drishyam 1 is, again, the USP of that film is the body of the person murdered could not be found. And why I'm taking this example? I'm taking this example because when Drishyam was made, it was made basis. It's a Malayalam film based on a Korean film, and then the Malayalam film was further evolved into Southern films, and then Viacom made a Hindi film called Drishyam. While this was happening, while the Drishyam was being made, one of the production houses acquired the right of Devotion of Suspect X through an agent from the author itself, from the publisher itself in Japan, to make a film. And obviously, because the story was so similar, on one hand, a film was made where no rights were taken. It was based on a Korean film, but the Korean film had acquired the rights of the Japanese novel. Indian producers made a film based on that Korean film without taking the rights, either from the Korean film or from the writer of the original story. And simultaneously, a production house had acquired the story rights. But they could not have made the film because it would have run contrary to the story. And if you see both the stories, they are very similar. But of course, coming back to the basic principles of copyright, while the idea of lost body in a murder is central theme of those stories, the expression, everything around it, the expression around it are very, very different. And there comes the practical example of the dichotomy of idea and expression. But the valuable portion of that copyright work, of that novel, had been used. One basis proper license, one without taking proper license. So if ever this matter comes out in a court, it will not, because both the owners of both the films in India is Viacom, so it will not come. But in case it did, then this question would have arose. What valuable portion of that novel has been taken in Drishyam, and could that be a defense against copyright infringement? Did the user of the subsequent work save much labor by using the copyright work? Look, copyright works are by no means inventive use. They are not patentable inventions. They are creativity. And the creativity, at the heart of creativity, is it's not necessarily a new idea. It's a new expression for sure. Because if it is not a new expression, then surely it is not copyrightable. It has to be original in terms of not the idea, but it has to be original in terms of the expression of a given idea. Because at the end of the world, there are only, in a creative world, there are only 7.5 plots of which you can write stories. And by way of a mathematical calculation, I'm still trying to arrive at that formula. I will need help from Professor Ghosh on arriving at a formula by all permutation and combination, given all the languages of the world. can we arrive at a finite number of the number of works that you can arrive on the basis of that 7.5 plots? And why is it important in the world of artificial intelligence? I will come back to it. So, did the user save much labor by using the copyright work? What is the quantum of sweat of brow that was used? What is the hard work? Did he add any little to what the original work was already there? Was the user's use incidental or substantive or central to his own use? What was it, just incidental? Sorry to say this, and many Bengalis might get offended, myself being a Bengali. Tagore took a lot of songs, the compositions of lot of Tagorean songs are based on Irish music, Irish folk songs, the tunes, or English folk songs. And that is where the difference between adaptive work and the transformative work comes. Similarly, a lot of other people might have got inspired, and that is where the defense lies in a copyright infringement, whether the work is adapted, derived, or transformed. So, whether the use is incidental or substantive or central. Could the user's work serve as a substitute for author's work? Most important question. If I just transcript a given literary work, or translate a film, or dub a film, and make it my own, can I do it? No, of course I can't. Mere replacement of a work in a given market is no authorship. Did the user circulate his work to the public to understand what has been the commercial outcome of it? Did the user fail to acknowledge the copyright work? Very important in research works. You can't write an entire thesis or an entire paper by taking everything from another writer and just quoting him by putting, the footnotes. Put everything, and 90% of the paper is within quotes with a footnote there. Can you do it from one single author? Even so, two questions: from one single author or from multiple authors without any originality of yours. Can you do that? Big question. Could the user's work replace the copyright work? Same as the few questions before that. Can it be replaced? Let's get into the section now. Section 52 of the Copyright Act says, following act shall not constitute an infringement of copyright, namely, not including without limitation, namely, specifically, which means these are the works of fair dealing, specifically enumerated in the law. And this is just the first part. There's a huge list of section 52. You can read it, applying to different parts. I have just taken the film part of it. And this is the overarching principle of section 52, which is there in 52.1. What is it? Fair dealing with any work not being a computer program for the purpose of, what are the purposes? Private or personal use, including research. Criticism or review, whether of that work or any other work. In any other work you're criticizing, you are taking parts of a given work. Reporting of current events and current affairs, including reporting of a lecture delivered in public. Now, each of these, please mind your all the words. Each of these words are very important in a given context, because in law, while the law is there in the statute books, when we go out in the court, we have to deal with each and every word as it applies to the facts and circumstances of each and every case. So private and personal use, very important. What I am doing with private use, where I have put up my personal use, am I sharing it somewhere? Big questions. Criticism of review. What is criticism, or what is a review? Is criticism mere reproducing any work? Can I criticize a film or review a film by putting out the entire film in my review process, or a book in a review process? I'm reporting a certain film. I'm just reporting it. Such and such film. Say Jawan has come as the 1,000 crore film in the box office, crossed 1,000 crore film in the box office, which speaks of regimes, which speaks against any regime, any given regime. And in the process, I show almost 80% of the film in clips. Same goes for IPL matches. I say, okay, India, Pakistan, India, New Zealand, Pakistan, England match is there. And these are some of the shots. And in the process, I show 90% of the film of the event. Can I do that? There's an explanation given for transient works, which are incidental storage of any computer program, is not itself an infringing copy. If a copy is not itself infringing, then such storage is allowed. Section 52(1)(u), what does it say? The inclusion in a cinematograph film of any artistic work permanently situated in a public place or any premises to which the public has access. I give an example here. The Taj Hotel in Mumbai, okay, which was attacked. It's a public architectural work. It's not a public monument. It's a private monument. It's a private building, but it's there in the public place. Can I use it as, in my film? Can I use it as a backdrop in my film repetitively? Any other artistic work in any public area or otherwise, if such inclusion is only by way of a background or is otherwise incidental to the principal matters represented in the film, i.e., these use of a building, of any structure or anything in the public domain. McDonald, there's a mark of a McDonald in the public place of that, that Joker sitting, that particular statue in a McDonald. If it is incidental, when you say incidental and not incidental to the principal matters, what do you mean? You mean simply that usage of that thing does not carry the story forward in a film or is not an essential element in a film. And that is the reason we go about and see the quantum of use of a particular material, of a particular copyrighted material, which is there. And one very important thing here to understand, what we are seeing here is a Copyright Act. You will still be under a trademark infringement if you are using a trademarked work in your films, because there is no such exception there. So if a McDonald thing you are using, you better take a permission or delete it. And that is one of the reasons why in film advertisement, where various brands, put their products in the film for their advertisement of their products, pay a revenue to the producer. So if it carries the story forward, then it's not an incidental use. And this very important thing, in relation to any literary, dramatic, artistic, or musical work recorded or reproduced in a film, the exhibition of such film after the expiration of the term of copyright therein. Now, what is expiration of the term of copyright? Somebody said about this publication of copyright work and it comes. Please understand, when you deal with that particular section, you will see that the counting starts happening from the calendar year subsequent to the year in which it was published. So suppose I have come out with a film or a music this year, the 60-year period will start counting from the January of 24. That's how the counting happens. It will not be from October 8th. It will be from the January of next calendar year. And any of these acts, if they are given a recognition, then a defense of fair dealing is applicable. Now, coming to these three different things about adaptive work, derivative work, and transformative work in the context of films. Adaptation, I'll come to the definition. It's already defined in Section 2A of the Copyright Act. Derivative work is not defined anywhere. It has come through various precedents. It's not defined anywhere, including Berne Convention. It's not defined. To the best of my understanding, there are Berne Convention experts there in the panel. But to the best of my understanding, just like how the word original is not defined, the word derivative is never defined. But obviously, literal dictionary meaning of it is something derived from the original. So if I have copyright over the original work, anything which is derived from there, I will also have right over it, unless I'm parting with that right, I'm transferring that right. So that is derivative work for you. In relation to any work, any use of such work involving its rearrangement or alteration. What are the common examples of derivative work? Translation. In case of films, prequels and sequels. So when you say prequels and sequels, what do you mean by prequels and sequels? What is there in prequels and sequels? What is the difference between a remake and a prequel and sequel? I mean, very literal meaning is that a prequel or a sequel takes the story forward or backward of the original story, original film. So some of the key characters or plot or elements of that film is either taken forward or either taken backward to tell another story. That is a prequel or a sequel. Animation work, again, is an animated version of a film. Metaverse. Okay, I will come to those new usages later. So these are some of the known definitions of derivative work. When it comes to, am I audible? Sorry, I'm speaking and I couldn't hear anybody. So am I audible to everyone?
Yes, sir, you're audible.
Oh, sorry. So that is derivative work. Translations, prequels, sequels. In the world of films, it is the dubbed versions. What is the difference between a prequel, sequel, and a remake? Remake, as the term clearly says, it's a remake of a given film. So when you remake a film, what do? You don't just dub the film in another language. You reproduce the film in another language. And in order to reproduce the film in another language, what do you make use of a given film? You make use of the dramatic work, that is the screenplay or the shooting script or the story of the original work. And why is that important again? Because when you are remaking a film, it is very important to see to check the chain of rights, whether the film producer had acquired the right from the story writer and the screenplay writer and or the screenplay writer to make or allow making of derivative works, allow making of remake works. Mohanlal allowed remaking of Drishyam. I'm coming back to one example right now. Remaking of Drishyam in all the South languages and Hindi. That is remaking. That's not dubbing. But same with Kanchana. Again, a South film. I don't know if you've recently seen a film called Circus of Rohit Shetty. Now, Circus is a film based on basically comedy of errors. Now, that comedy of errors plot of Shakespeare was adapted into a Bengali novel at some point in time. That Bengali novel was made into a Bengali film where Kishore Kumar acted. That Bengali film was made into a Hindi Kishore Kumar film I can't remember the names right now. That was made into a Sanjeev Kumar Hindi film. And there are various language versions of it. And then there is, of course, Circus, which was made recently. They didn't take any rights from the makers of Sanjeev Kumar. Why? This is based on comedy of errors at the end of the day. That is derivative work. I don't know if you've heard the film called Satya Pe Satta, famous film, dual role of Bachchan with 7 brothers and 7 acts. And there was a time when Bollywood producers were asking for the rights of it. So we delved deep into it. And there's a Hollywood film called 7 Brides for 7 Grooms. But this again is based on basically a Greek mythology. So where do you take the rights? These are all difficult questions, and one has to in a creative world, a story can travel, a story can expand, a story can develop. So when you are in the process of developing a story for the purpose of making a film, you have to make sure that you're not infringing anything. When I'm saying not infringing anything, you are not infringing, not in terms of personality rights. That's a different area altogether. I'm just saying infringing in terms of copyrightability of a work. When you're not infringing means you are not copying verbatim from you. And there it comes the definition of transformative use, where what is questioned is what is the degree of originality or newness, not inventiveness, because there's no invention in copyright, there's newness of expression or originality of idea or expression that has been incorporated in a given work. Let's see the definition of adaptation. What does it say? In relation to a dramatic work, conversion of the work into a non-dramatic work. In relation to literary or artistic work, conversion of the work into a dramatic work by way of performance in public or otherwise. Very simple. Take a story, make a screenplay of it, and then perform it. Can't do it. That means adaptation. In relation to literary or dramatic work, any abridgment of work or any version of the work in which the story or action is conveyed wholly or mainly by means of pictures in the form of suitable for reproduction in a book, comic books, or in a newspaper, magazine, or similar periodical. The entire controversy around and it's a very, very important judgment for the film industry. For some reason, it is being ignored these days, is the judgment, Delhi High Court judgment of the Satyajit Ray film called Nayak. It's a very, very important judgment because Penguin wanted to publish a book out of the screenplay. And the son of the director, who also was the screenplay writer, objected to it and said that this right was never given by my father to Bansal Productions, the producers of the original film. Now, pre-2012, basis the 1977 judgment of Supreme Court, producer, when he acquired the rights, he acquired everything. Now, presumably, in this particular transaction, the producer had not taken all the rights basis an agreement. And so the presumption lies that what has not been taken by way of an agreement by the producer from the author has been retained by the author and passed on to his son. And that is how the case was successful. And that is where the role of the lawyers are today. So if you look at any of the contracts today of the studios, particularly the big studios, they would take everything from you. Until very recently, pre-COVID times. Sorry to say, I was part of that side of the debate those times. Post-COVID, obviously, over a period of time, things have changed. And they are in process of changing. Why has things changed? Authors have come to realize of the literary works in the film and perspective, in the film domain, that while they are giving away the rights, while they have the royalty rights under the new provisions of the Copyright Act to have, which they can enforce, but what they're giving away is the derivative right. So tomorrow, a producer who has acquired the rights can actually appoint another writer and get to write the prequel and sequel without paying a penny to the original writer, which is a disservice to the creativity of the writer. But having said so, is the writer original? What he has written, is it original? Is his expression original? What is the guarantee that what he is writing or composing or drawing or whatever work he's creating is original? Because there's no database to check the originality. We'll come to that when we discuss artificial intelligence. We put in the artificial intelligence context there. In relation to a musical work, any arrangement or transcription of the work. So the musical work for adaptation has been included. Ki kya karna hai, nahi karna hai. In relation to musical work, any arrangement or transcription of the work. You change the lyrics, not allowed. Any arrangement, you rearrange the compositions and you create new music. That is not allowed, as in that is an adaptation. And that lies with the original producer or the author of the work. The last one is in one way or the other can be defined to have a transformative work in relation to any work, any use of such work involving its rearrangement or alteration. Rearrangement or alteration. Now, what are these terms and in what context they are used is a very factual and subjective issue. Now, some of the precedents that we have seen these days. 2012, Shemaru Entertainment versus News Nation. Bombay High Court restricted the news channel, it should be news channel, titled News Nation from incorporating, recording, distributing, or broadcasting anything from the catalog of the plaintiff.
Ayan,
Yeah,
your PPT is not coming.
not coming.
No, just suddenly gone.
Oh. Hold on. Now?
Still not coming, still not visible.
The screen is visible?
No, the screen is not visible.
Now?
Yes.
Now?
Yes, it's visible.
Thank God. So this is about news. What can be used and what can't be used in news. There are several cases on IPL matches from the broadcasters. Earlier, the news channels would show almost the entire IPL matches. And there have been cases by Sony, by Star against these broadcasters, and that has been put to stop. T-Series case, Delhi High Court opined that while determining what constitutes reportage of a current event as criticism or reviews, court must take a liberal approach. The court further opined that using the copyrighted work merely for copyrighted work does not amount to unfair usage, and that any transformative work will not be fair usage under the fair usage doctrine. There has to be an element of newness. I mean, you are just reporting everything as is, without anything there, any substantive material around it. Saregama, Calcutta High Court stopped streaming or filtering another copyrighted sound recording on a website is not permissible. Copyrighted content is being downloaded by some other website. This will lead to an infringement, cannot be permitted. On this, while I was in Saregama, there was an incident, and let me tell you, it's a very important thing. And this is about new age technology. I don't know how many of you have used, some of the young people must have used or have seen the usage of TikTok. Now, TikTok is not there in India, but similar technologies are there, like shorts, YouTube shorts are there. In Instagram, there is a feature where you can take a video on the go using your phone. Okay, you can take a video using your phone. And then there are these apps which provide access to the sound recording. You can attach those sound recordings to the video that you have taken and create reels and then publish it on that website. I don't want to name the websites because most of these cases have been settled out of court by most of the music companies. What happened is these platforms took the defense under the IT Act, saying it's 79, Section 79 IT Act defense. We can't do anything about it. We are just providing the platform. But what are you providing the platform for? Is the platform being provided for a passive use or an active use? By making available sound recordings on a website, you are encouraging, it's a case of vicarious liability, you are encouraging people to take portions of those sound recordings, put it in the videos and publish it on your website. And those reels is your business model because that's where you get your earnings from. The influencer or that particular actor shares a part of his revenue with you, basis the number of followers it has. So you're not a passive person who has provided the provided the platform. You're an active provider of the platform. And basis those cases, what happened was a string of settlement agreements where multi-crore deals were signed by the music companies, not just Saregama, all the music companies almost, with these new age platforms, including TikTok, including Amazon Music, including YouTube, including Instagram, everyone, Facebook, everyone. Multi-crore deals. Why? Because the defense was, copyright infringement defense was, that we are just providing a platform. No, you're not providing a platform. You are actually instigating a copyright infringement. Now, what is the defense in these cases? What is a transformative use? So whether a use is transformative is the question of whether a second work must transform the content of the original. Something new has been added. Something interesting has been added. Something new expression has been added. Transform the purpose of the original. What is the purpose? Parody. I take a clip and make a parody of it. I just reproduce it in no good way. I make a parody of it. That is the new way. And two basic principles of transformation. One is a content transformativeness. One is a purpose transformativeness. You're transforming the content itself and you are transforming the purpose itself, why it has been used. In a famous case of Blanche versus Cool, US court has held that work was transformative where it made several aesthetic changes to the original work, used it in a collage with other works, and had different purpose. Other than the original. These are very important issues around the transformative use in the context of film. I don't know how many of you have seen the film 83. In film 83, there is a particular shot. Why I'm saying 83? Because I was associated with that film, so I take a bit of a pride in mentioning that film. So in that film, there's a shot where cricketers are traveling by bus from one place to the other, and on the bus there is a TV, and in the TV there's a song which is being played, which they are themselves humming while going on their way, of Ek Duje Ke Liye, Hum Bane Tum Bane Ek Duje Ke Liye. So there are two things, two rights that were taken in that shot. One was the lyric right, because the actors were humming it. The other was the right of the clip of that particular sequence of the film. Somebody might say, why can't, particularly the academics here might say, and I am also intrigued by that question at times, why can't de minimis, the principle of de minimis, be used as a defense? Remember one thing, again, coming back to the original concept of fair dealing versus fair use. What is fair use? De minimis use is a fair use concept. It's a creation of law. A certain minimalistic use, not defined anywhere, 3 seconds, 2 seconds, 1 minute, 2 minutes, not defined anywhere, whether it constitutes a de minimis use or whether it will fall under fair dealing. Certainly it will not fall under fair dealing, because you are using a copyrighted material in another film, so that will not that is not allowed. It will have to be a de minimis use. If it has to be de minimis use, you have to show that it is restrictive to certain number of seconds. But that number of usage of seconds is not defined in any law. But court will just go by the fairness of use. And that was the principle in the pre-digital world, where a film will come and then go from the theatrical. Maximum it will come out in DVD or once or twice in the TV. But what is happening in the digital world, a film never goes away. It is out there in the systems. It is out there in the virtual world forever for you to pull and see and consume. So that minimalistic use is repetitive use in repetitive forum, in repetitive platforms. So that entire concept of de minimis as a defense has gone away from the Indian jurisprudence. And that is exactly the reason that today, for smallest use of a clip of a song or a film or lyrics or an artistic work, you have to take license, because the nature of exploitation has changed. Now let's come to the entire new world of metaverse and artificial intelligence. I have some time, right, Mr. Jotwani?
Yes, please. Yeah, we can spend some time, but I really want to keep some time for the Q&A also.
I will take another 5 minutes. I won't. This is, though it's not my area. What is this trouble around this strike that is happening in US? Let me just try to show you something. Just a minute, if I can. You see my screen? You can see the ChatGPT screen, can you? Hello?
Hello.
You can see this ChatGPT screen?
Yeah, it is coming.
Okay. Now let me. I believe all of you must have used it in some way or the other, right? I have been trying to see what is several landmark cases and all that today, while I was trying to prepare this PPT. So as a use of a tool, as some of the speakers were saying. Let me just type here something. You can see the ChatGPT screen. Write a story about loss of copyright materials in the Tagore style. And I use the same thing and say in, let's see if it does. Have you all seen this? Have you seen the how ChatGPT has just created the stories?
Yes, sir.
Interesting, isn't it? This is ChatGPT. This can create long language models. Then there are Dela, which can create images. Then there are similar softwares or algorithms which can create images. There are softwares which can create versions and music compositions using this. What is problematic here? I fail to understand. Acha hai na? Any writer can write, I can publish this. And I can create a book out of it. What's the problem? It's so helpful. I can create music out of it, not out of this, but there are other softwares. At the end of the day, whatever a human mind is creating, human cognitive faculty is a sum total of its experiences. If I have never been to Kashmir, I've never read about it, never seen a picture of it, never have anything to do with Kashmir, I could never tell you about Kashmir, can I? But I can tell you about other mountains. But only if I have been to Kashmir can I tell you about Kashmir in some creative expression. So human brain at the end is a sum total of its experiences. Artificial is a huge human brain where all these data sets are all fed and it is creating something what you want. If I have read 100 stories of Tagore and today I have to write something of my own, it is inevitable that what I write will have some transformative use, not just adaptive use, certainly not adaptive use, certainly not derivative use, but transformative use of Tagorean work, of Munshi Premchand work, of Javed Akhtar work, of, God forbidden, but Chetan Bhagat work also might be, or Ruskin Bond work, or whoever. So my brain is a sum total of that. If I read all these materials, I will reproduce all these in my style. That style will get echoed. That is transformative authorship. That is allowed as a defense in copyright. So what are the authors and the screenplay writers and everybody is upset about? Only difference is it's not a human, it's a machine, and every a machine is reproducing it. If you take this example, now I using ChatGPT have written this script, written this piece, whatever you could see on the screen. You know this usage, and the prompt that I have given here, write a story about loss of copyright materials in Javed Akhtar style. You use the same prompt or different prompt to write another story. So what is happening is, mathematically, and correct me, Dr. Ghosh, again, if I am correct mathematically or not, the degree of differentiation between every work generated using artificial intelligence is very, very slim. It might happen today that every other work created using artificial intelligence is almost infringing. That is one possibility. And what is this entire grievance of the writers about? Grievance of the writers is about loss of livelihood, obviously. Now, whether they will, now the technology is disruptive. Whether copyright can be given to it is a big different question. Whether studios can use such, things to write, new work, it's a technology. Just like they can use different technologies for film shooting, for VFX, they can use this technology also to write scripts. Whether they can use this technology to create music, of course, they can use different technologies to create music. Can they use these technologies to use performances? Of course they can. Now, there is a problem in the difference between the performances and creative work. The difference is that performance has a concept of personality rights built in it, which is not necessarily the case in a literary work. Obviously, when I'm saying a work has to be Tagore style or a Premchand style or a Javed Akhtar style, there's an element of personality, an element of moral rights imbibed in it. A paternity right is imbibed in it. But if I don't say anything, still this machine will give me a story in one way or the other, which I will have a right to change. And can that be stopped? But when it comes to performances, it's different. Say, suppose there is a Kishore Kumar song. Now the technology is such, using voice sampling, you can take a Kishore Kumar song which was sung by Kishore Kumar, but use the voice of Mohammed Rafi to re-sing, re-perform that song. That you can do. And Bombay High Court has already held that personality rights cannot be extended beyond the death of the person. It's an interim order still, but still that is the law right now. So people are using left, right, and center all these, all these works, personal works, and without taking proper rights from if they're dead, they don't take any rights anymore. But can I do the same with Arijit? Kishore Kumar's song, using voice sample of Arijit, I make, without engaging Arijit, I make that song to be sung by Arijit, a Kishore Kumar song. Is it possible technologically? Yes, it is possible. I don't know how many of you have seen a Sholay sequence reshot with Hollywood actors, and you cannot differentiate that they are not the real actors. Now, that is a personality rights issue that is not necessarily a copyrights issue, particularly if that person is alive. Maybe that is where the AI regulation has to come in, that what can be used, the AI can be used for what, in what context. But, and that is where the regulations have to come in. And regulations have to come in not just municipal laws, not just national laws. There has to be a treaty around it. So that nobody sitting nowhere in the world can do this with Indian works. Or I can't do the same with with other countries' work. You can just replace the face and use somebody else. Instead of Jackie Chan or a Bruce Lee, you can put Akshay Kumar there and use the entire sequence. Can you do that? You can't, because there is a choreography involved there. Say suppose some film is out of copyright. It's in public domain. Can you still do it? You just change the faces. You're not taking the script. You're not doing anything. Allowed now. You can take the film and do whatever you want to do with the film. What transformation are you using? Is use of artificial intelligence a transformative use to create a new work, or it's an algorithmic machine use not to create anything new? And what is new? And we come back to the question of the monkey taking a selfie. Who is the owner of that snap? Certainly not the monkey. Certainly not the company of which the phone is. Or is it the person who owns the phone? Who's the owner of that snap if a monkey takes a selfie? We come back to that question. Thank you. I would end with that. There's no definitive answer to anything. I would end with that. Thank you very much.
Hello, Oyan.
Yes.
I have just two things to say. One is about some correction. You said about comedy of errors, right?
Comedy of errors. Yes.
Now, it was first actually adapted by Ishwar Chandra Vidyasagar.
Yeah.
And the film was made called Bhranti Vilas.
Correct.
Starring Uttam Kumar Savitri, not Kishore Kumar. Kishore Kumar, Do Duri Char was much later. And finally, it was Gulzar who made Angur with Sanjeev.
Correct. Right. Yes, I might have
little correction.
mixed up the facts. Yes, I might have mixed up.
There is one quick question. Section 2A adaptation. Okay.
Yeah.
Films not included, but sound recordings are. What exactly mean?
No, same adaptation could have been used for films also, no? But it was not changed.
No. What films you can, but then you said sound recording not.
Sound recording is not kept out of it. I'm saying sound recording has been included in the adaptation.
Films not included, but sound recording is. That's what you said. 2A, section 2A.
Correct. It is there, na? I showed you I can share the definition.
No. I have seen that. You said that on that basis. They just want a clarification. That's all. Nothing else.
Why, I don't know. I'm saying it is there. So that's my question. Why if the adaptation work was there for sound recording, why was that not included for the films?
Okay.
It should have had for the films also, right?
Thank you very much.
So thank you so much. Mr. Ayan was the last speaker here. And with this, I'll just like to convey a vote of thanks to the people who made this event successful. Starting with our coordinator, Jasmine Hora, who worked really hard in coordinating with speakers and participants and with all the government dignitaries who were there. I would also like to thank Mr. Lalo Khan in my team, who was actually responsible for creating a lot of content and website there. So thank you, Jasmine, and thank you, Lalo. And of course, thanks to all the speakers Dr. Samuel for giving us fundamentals of copyrights. And Mr. Raghavendra gave us some advanced dose of copyrights today. It was really, a session where we all learned a lot. In fact, as I said, he's an encyclopedia, and we did learn a lot today. And thereafter, we had Mr. Amit Devji. He talked about historic AI, but from historic perspective. So a lot of these things were again new to all of us. In knowing AI, we know it AI that actually from 2022 and 23 when ChatGPT became common, but there is a lot of historic perspective that he gave. Hima Ghosh again on the copyrights part of it. She talked about some a different perspective and the research, her research into the copyright, and finally we had Supran Sen. He gave a very good. He shared his vast experience in the film industry, and thank you so much, Mr. Supran Sen. Ayan Rao Chaudhary again, a very good presentation on the fair use from all perspective. So thank you so much, all the speakers who were here. Thanks to Dr. Pinaki Ghosh, whose brainchild this was, to make this, to come out with the idea for this conference. I would also like to thank all the participants who were there patiently listening and learning. So the students here will of course get a certificate here. They can contact Ms. Jasmine. They will get a certificate here. Again, thank you so much, everyone. And
Thank you very much.
can bounce on to us.
Dinesh, thank you very much.
Thank you, Ji. Thank you so much.
See you,
Delighted.
see you soon. Hope to see
Delighted.
you soon.
Yeah.
Thank you, everyone. Thank you.
Thank you, everyone.
Pinaki, thank you.
Thank you.
Pinaki, could you hear me?
Yes, I can hear.
Thank
Can
you
hear
very
me?
much. Thank you very much.
Thank you.
At least it's NasCap, so.
Thank you, Supranda. Thank you, Mr. Dinesh.
Thank you, everybody.
Dr. Ghosh. Thank you. Bye.
Thank you very much. Chalo.